La comentarista de este panel, la doctora Elena Alviar y el doctor Rodrigo Uprimi.
Alviar and Rodrigo Uprimi.
El profesor Axel Schenscher es
cast a light on judicial activism. I want to place a question mark behind judicial activism, or at least one particular aspect of this activism, and that is the notion of optimization. This notion is closely tied to the theory of Robert Alexy and others about legal principles that require proportionality and therefore balancing, and in the end, a balancing with optimization. While I am not averse to the theory of legal principles, I am critical towards in understanding of this principle as an optimization task taken up by the constitutional courts. Understanding legal principles without the notion of optimization allows for a less fine-tuned control of judicial review and therefore avoids a hyper-judicialization within the balance of powers. To illustrate this, I will briefly turn to 4 social rights decisions in Germany and Switzerland before I come to the 4 questions that were presented to us, to our panel, by the Constitutional Court. The first case is about taxation. Germany's Federal Constitutional Court had always stressed that taxation is a matter of political discretion. Even very high taxes were not considered a violation of property. In 1995, however, the court came up with a new rule that income tax and property tax together may not exceed 50%. This new rule about sharing in half between citizens and state came as a surprise for the legal community. According to the published opinion of the one dissenting judge, the decision lacked the self-restraint adequate for a constitutional court. The court should have acknowledged the legislator's prerogative in developing criteria for who has to pay what as a tax. Setting absolute limits would, on the long run, render the political system powerless in face of future dynamics. Without stating so, the majority of the court had resorted to economic rationales. By pulling economic optimization into the law, the court was binding the hands of the legislature in the future. What happened to this activist decision of the Federal Constitutional Court in Germany? Well, 90 years later, when all of the former justices had finished their tenure, the court revoked its earlier decision. Now it held that the sharing in half rule was only obiter dictum and not binding as a general rule. While the justices still used a proportionality test to check on the violation of the property right, the balancing did no longer support a specific limit. Rather, it was deemed the legislator's domain to find an adequate balance for the property principle on the one hand and the social state principle on the other. So in the end, judicial restraint prevailed over judicial activism. However, the damage had already been done. In 1997, only 2 years after the initial decision, the legislator in Germany changed the system of taxation by no longer raising any property taxes at all. Frequent attempts to re-establish property taxation in order to achieve a more just overall taxation system, particularly with regard to very wealthy citizens, have since failed. So this one case of judicial activism of more than 20 years ago has a limiting impact on politics until today. The second case is about places to study medicine. It shows that judicial activism is not a thing of the past. The Federal Constitutional Court has always acknowledged the social right of participation in this subsidized medical education system. Places at medical schools are expensive and have always been scarce. Within the federal system, the politicians of the German states came up with a scheme to assign the places. Some of the applicants could only study medicine after a waitlist period. Far back in the 1970s, the Federal Constitutional Court of Germany had acknowledged this system of so-called numerus clausus assignments. But when the issue came up again 1 year ago, the court adopted new guidelines, including a limit on the waitlist. Only for some years after high school may students gain access to medical school by waiting their turn. This was based on empirical analysis about what student group was more successful on average. By curtailing the waitlist procedure, the court restricted the states so much that the current political discussion leans towards abolishing the waitlist procedure altogether. This new numerus clausus decision is an example of judicial activism. The court's decision is part paternalism, part political regulation. It is paternalism towards the students who are told to better choose a different course of studies. And it is political regulation towards the states because it curtails their current distribution scheme and even sets guidelines for future designs without waiting for politicians to come up with their own ideas. All of this is based on the court's own cost-benefit analysis that, in effect, prioritizes utilitarianism over autonomy aspects of the right to choose one's course of studies. The third case is about monitoring for social security payments. Generally, no monitoring is required. The Federal Constitutional Court in Germany acknowledges the politician's prerogative of factual prognosis about what kind of regulation fits the demands of the future. However, if the fact-finding by the legislator has been lacking, or the context of the social right is subject to dynamic change, the court uses a monitoring duty in order to ensure a dynamic protection of fundamental rights. In the case of reduced social security payments, the court found the legislative fact-finding lacking. Rather than just stating the error and requiring the politicians to fix it, the court stated that the legislator in the future was duty-bound to continuously monitor social security payments and adapt them whenever any change in the economic context occurs. If we distinguish this form of monitoring from the monitoring by the Colombian Constitutional Court, the main difference is that the German court just triggers a duty that has to be fulfilled by the legislator in the form of self-monitoring. Accordingly, there is no additional burden on the court in administering the consequences of its past actions. The court publishes the decision and then lets go of the case. If the legislator violates its monitoring duty, a new case challenging this mistake can be brought before the court to address the grievance. While establishing a monitoring duty is in itself an example of judicial activism, because it significantly reduces the discretion of Parliament about how frequently it wants to update the law, this kind of triggered self-monitoring by the German court is still less intrusive on the balance of power than the Colombian monitoring system seems to be. How does judicial review work without judicial activism? For this, I will now turn to Switzerland. This fourth and last case is about taxation on single-parent families. About 10 years ago, the Swiss Federal Court found that the tax burden on single-parent families was unconstitutional. It violated the social right to taxation according to one's economic potential. Accordingly, the federal court declared the respective law unconstitutional. In Switzerland, however, constitutional review is limited. The courts can declare cantonal laws and federal ordinances null and void, but whenever a law has been adopted by the national parliament, the unconstitutionality has no immediate consequences before the national parliament itself changes the law. This judicial restraint does not come by choice of the court, like in Marbury versus Madison, but it comes by order of the Constitution. What happened in this case? The federal parliament amended its tax law 3 years later, but the amendment needed to be implemented both by the Federation and the cantons. Therefore, the injustice was not abolished for more than 6 years after the court's decision. This delay in providing redress is the cost to be paid if a limited review power takes care of judicial activism. What does this all mean? We have seen cases of social and economic rights education in Germany, where optimization leads to judicial activism that in turn shifts the power from politics to the courts. The sharing in half rule was invented by an activist court and did real harm to political practice. The case about medical school applications has at least one harmful effect already evident today. With the court's focus on efficient allocation of funds, the legal rationale has been switched from Kantian deontology to utilitarianism. It is no longer the individual autonomy to become a doctor that counts, but the investment of public funds in the most promising human instrument of healthcare. There are at least 3 different ways of avoiding the optimization trap that I've sketched with these remarks. The easiest and most effective way is, of course, the Swiss method of prohibiting judicial activism altogether. We have seen that this comes at the high price of less effective implementation of fundamental rights. There is, as a second way against optimization, the strategy to avoid legal principles as much as possible and rely on legal rules. This is the approach most prominently displayed in Anglo-American law. To avoid legal principles means avoiding the proportionality test and balancing. In a framework of legal rules, rather than principles, simpler tests, like the reasonability tests, can be used that do not lean towards optimization by courts. The third and more controversial way of avoiding optimization by courts is to reconceptualize legal principles and the balancing procedure. In my view, it is the most appealing way of dealing with the problem of undue judicial activism. We should abolish the notion of optimization while adhering to the proportionality test. That way, we will understand legal principles as open-ended norms that require balancing wherever they collide. But we will avoid the fine-tuned rulings commonly associated with balancing procedure. The court's decision would be restricted to an all-or-nothing statement regarding the relative weight of the colliding principles under the specific circumstances of the case at hand. With this in mind, I will now turn to the 4 questions presented to this panel. After my critical view on the small-scale activism of the German court, it is no wonder that I'm somewhat reluctant towards the much stronger activism of the Colombian Constitutional Court. But there are differences in the institutional setting, and therefore I will try to differentiate. Regarding question 1 about the extent to which constitutional courts should take the place of the legislative or executive branches, in my view, they should not take the place of the other branches, even if social rights are systematically under-enforced. Instead, the Constitutional Court should stick to case-by-case rationales in order to preserve regulative discretion for the future. At most, the court can aggregate various cases into one common decision about remedies as was done in the healthcare decision T760 of 2008. In my opinion, the decision T25 of 2004 is on a different level from this healthcare issue. Taking care of internal displacement goes towards the right of dignified life that lies at the core of fundamental rights protection. With emergency humanitarian aid, there is no balancing at all, because it belongs to the minimal core of human rights that must be satisfied under all circumstances and at all cost. Therefore, the court's robust monitoring this case might be warranted, but not because it is so innovative, but because it is a measure of last resort. Regarding question 2, financial restraints of the state are a necessary part of the balancing of countervailing principles and therefore should be taken into account with the enforcement of social and economic rights. In particular, to avoid unnecessary bailout funds and other expensive emergency measures, the court should leave macroeconomic discretion to the legislative and executive branches of government. The Colombian Constitutional Court has enabled such flexibility in the past. For example, when it decided in the budget decision C-1064 of 2001, then it was not disproportionate to limit public servants with better salaries. Regarding question 3, in my view, decisions about resource allocation and public policy do not belong to a constitutional court. It is not their domain. Strong remedies, on the other hand, remedies that, according to Taschnit's decision, are implemented, are a legitimate instrument to enforce social rights. To preserve the balance of power, they should be narrow in design, adopted by individual litigation, and in the form of specific remedies or damages. In other words, the strength of remedies should be based on the degree of obligation, not on a broad scope of the order. And finally, regarding the last question, question 4, about the follow-up. The monitoring system established in T25 and T760 is both innovative and disturbing. Rather than running the monitoring by the court, the follow-up should take the form of monitoring within the legislative and executive branches. The Constitutional Court should not retain its decision indefinitely. It should issue a final order to pass the ball back to the other powers. Thank you very much for your attention.
Muchas gracias. Quiero invitar a continuación al señor David Vilchitz, es profesor de la Universidad de Johannesburgo y director del Instituto Surafricano para Materias Avanzadas de Derecho Constitucional, Público, Derechos Humanos y Derecho Internacional de esta universidad. Obtuvo su doctorado en Filosofía y su PhD en Derecho en la Universidad de Oxford y es el secretario general de la Asociación Internacional de Derecho Constitucional. Bienvenido, profesor.
Buenas tardes.
I would like to thank the President of the Constitutional Court for the invitation to this wonderful forum and all of their personnel for their help.
Social and economic rights provide the essential basis which are necessary for human beings to live decent lives in dignity. Everyone needs housing, food, water, and healthcare when we are sick. Yet in many countries, such as my own, South Africa, and here in Colombia, many people lack access to these basic goods. If these are fundamental rights, how are courts to give effect to them? How can we bridge the divide from rights on paper to rights in reality? Socioeconomic rights play an important role all around the world. Yet there are a number of particularities in the global South. There is a huge need and lack of access to these rights, leading to much suffering. There is a failure adequately to take account of this need through the democratic systems. And there are dysfunctional bureaucracies and the lack of ability to deal with these problems. And this has raised the question concerning the role of the courts. Let me say up front that I believe courts have a critical role to play in giving effect to these rights, particularly in the global south, and addressing the needs of the vulnerable. Colombian courts, and the Constitutional Court in particular, have grasped these difficulties and creatively developing ideas of what is possible in relation to these rights. I agree with Professor Gargarella this morning that the actions have in many ways been spectacular. We can share experiences, but also learn so much from you. I will not, though, focus my presentation on the question of the role of the courts, though I should say up front I will disagree with some of my colleagues on the panel who promote a more conservative and passive role of the courts in these circumstances. The key question I'm going to focus on is on adjudicating these rights. What do they provide for individuals, and how do we determine their content? One of the key roles of courts, in my view, is to set constitutional standards for other branches of government against which their programs can be tested. Courts can help prioritize particularly urgent needs that require attention where there are so many competing needs. In this paper, I will focus on a particular problem that has arisen in a South African case recently concerning defining acceptable standards of medium-term temporary accommodation for people who would be homeless. In defining such standards, it has become almost a mantra of human rights law that all human rights are interdependent and interconnected. But the question I'm going to ask is, what is the role of one human right in giving content to another? How can we understand the relationships between different rights? As I mentioned, the catalyst for these explorations is a case called Dladla versus the city of Johannesburg. I will outline two starkly different approaches by the majority and the minority, and I will consider how these issues play out in circumstances where there is a stark need to prioritize resources in circumstances of emergency and temporary accommodation, which are circumstances that face courts in South Africa and Colombia. So the right in the South African Constitution is Section 26, which reads, everyone has the right to have access to adequate housing, and the state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of this right. What happened in this case? It emerged from a prior case called the Blue Moonlight case, which dealt with an application for eviction by a private company which owned a set of run-down premises in the city of Johannesburg. A group of people from that property had been living on it for a long time in very poor conditions. And the Constitutional Court essentially held in that case, firstly, that private parties, the company, had a duty temporarily to allow unlawful occupiers to remain on their properties before alternative accommodation could be found for them. A big question concerning the obligations of private parties, something I'm working on in other areas. It also held that the local municipality had a duty in the case of both private and public evictions to provide alternative accommodation to individuals where they risked being rendered homeless. The court ordered the city of Johannesburg to provide alternative accommodation after the eviction. Now, the facts of the Dladla case relate to the manner in which the city gave effect to this order. It placed the people in a shelter run by a non-profit company for destitute individuals. The shelter forced them to comply with two rules, which were subject to challenge in this case. The lockout rule stated that residents could not remain at the shelter during the day, from 8 in the morning to 5:30 in the evening, and they could not leave after 8 o'clock at night. Those that returned after this time were not allowed in and had to sleep elsewhere, which often meant sleeping on the streets. This meant, for instance, that those on night shifts had nowhere to sleep during the day and were forced to wait outside the shelter and spend time in unsafe parks. The second family separation rule involved separating out male and female residents. This meant that heterosexual couples could not remain in the same dormitory, and male and female partners were separated. This situation meant that one of the parents, which often landed up being women, had to take care of the children. In some of the cases, minor children were removed from their parents, given the shelter was not a suitable place for them to live. A number of the applicants could not stand these oppressive rules and moved out of the shelter, even if this meant lacking any alternative accommodation. And the case concerned an interdict to stop the city and the non-governmental organization from enforcing these rules. The majority of the court held that the accommodation offered to the people was itself satisfactory. And because of that, the right to housing was not implicated in this case. Instead, other rights were violated by the rules. The lockout rule violated the right to dignity, to privacy, and to freedom and security of the person. The family separation rule violated the dignity and freedom and security of the person. These violations could not be justified, and consequently they were unconstitutional and were not to be enforced. What are the problems, though, with this approach of the majority? The majority importantly said the right to housing is separated strictly from other rights in the Bill of Rights. But it seems to me to be mistaken to distinguish between the actual concrete infrastructure surrounding a home and the conditions under which individuals live in a home. Ultimately, the question comes down to, why is it that individuals have an interest in having a home? The Dladla case is an important instantiation of this point. The city tried to reduce the interest of the individuals in housing simply to having a shelter in which to sleep at night. The case, however, illustrates the point that individuals need much more from a home than shelter, even a temporary one. Consequently, there are significant difficulties in interpreting the right to housing simply to cover these structures without addressing the very point of those structures, which is to render the life of individuals who live therein as having a decent quality. Now, one of the minority decisions in this case by Justice Cameron, who is one of the great justices in South Africa and who is at this conference, so he will speak to you tomorrow, and he stated that temporary accommodation of necessity entails more than just providing a roof and 4 walls. It must include all that is reasonably appurtenant to making the temporary accommodation adequate. The provision of housing, he said, entails not only the delivery of a building or a tent, the conditions the state attaches to the accommodation are part of its provision. Justice Cameron saw the question as being whether the actions of the government in giving effect to the court order were reasonable in terms of the South African constitutional right, which requires reasonable legislative and governmental action. Justice Cameron reasoned the rules violated dignity, freedom of security of the person, and as a result, they were unreasonable and therefore unconstitutionally violated the right to housing. The primary right for Justice Cameron was the right to housing, but other rights could be used to fill out the content of the housing right. Now, what can be said for Justice Cameron's judgment and critically, one of the major debates in South Africa concerns this reasonableness standard and whether it is adequate to give content to the meaning of rights in the Bill of Rights. Justice Cameron's reasoning, in my view, I'm a critic of the reasonableness standard, essentially bears out the points that reasonableness standard lacks adequate content, because in his very judgment, he has to give content by reference to the violation of other rights as a ground for finding a failure of reasonableness relating to the right to housing. However, in contrast to the majority's approach, which essentially tries to determine the particular content of the right to housing as a distinct right in a very narrow way to other rights, Cameron's approach differs in terms of the kind of right that housing is, and I agree with him on this. The housing right is a composite right for Justice Cameron, which embraces multiple concerns and the interests protected by other rights as well. Thus, a house will not be adequate if it lacks privacy or fails to provide us with a sense of security. Consequently, the very standard of adequacy must embrace these other interests and the rights which protect them. We cannot delineate the contours of housing rights without considering their relationship with other rights. So what then does this all mean for temporary accommodation? The definition of a threshold by courts for temporary accommodation is really of vital importance, given the scale of the housing crisis facing many of us in developing countries. Indeed, it is unlikely that even in 10 to 20 years, everyone will be in housing that meets full standards of adequacy. We thus need three types of constitutional standards, in my view. We need a standard for emergency temporary accommodation. We need a standard for medium-term temporary accommodation. And then we need a final standard for adequate housing. As such, there is a challenge for courts to define these thresholds. And the key point that I'm seeking to make here is doing so is going to require reference to the interests and values, at least in relation to housing, in relation to other rights. So let us go to the emergency minimum core, or determining the threshold. I have argued in my book, Poverty and Fundamental Rights, which was just recently translated into Spanish with Marcial Pons, that the minimum core should be determined in terms of the necessary conditions to avoid threats to survival. Now, it might seem that the Dladla case poses a challenge to this view, because the facts in Dladla show the insufficiency of focusing on such needs alone. People do not only require shelter that allows them to survive, but also conditions which enable them to be treated with a minimum level of decency and respect for privacy, security, and dignity. In responding to this charge, it is necessary to understand that the idea of a minimum core is not meant to determine the full range of entitlements of individuals in relation to housing. It is rather meant to identify the very basic minimum that individuals need in relation to specific rights. That is helpful, for instance, in enabling a definition of what must be guaranteed in situations where it is not possible to realize a higher level of provision. Thus, in situations where refugees are suddenly displaced, in circumstances of flood or fire, or simply where higher level provision is beyond the capacity of the government, it is necessary to determine a minimum below which people should not be allowed to fall. That minimum does not in any way mean that is all individuals can or should expect. This response raises the very debate that has been canvassed between the majority and the minority. In relation to the majority's approach on differentiating strictly basic shelter from any other interest, I would argue it is incoherent on its own terms. The standard of even emergency minimum core housing must be determined in relation to survival and the preservation of life or basic health. Housing and the basic conditions for human life can be seen to be fundamentally intertwined. In terms of the integrated approach of the minority, housing is a composite right, so it is impossible to develop minimum standards without reference to other interests. The problem for the integrated approach is that it could avoid the hard challenge, which Justice Cameron recognizes in his judgment, which relates to the fact that there may be a need sometimes to prioritize certain dimensions of our interest in housing over other situations in real situations of emergency. Privacy, for instance, may need to give way to ensuring basic shelter that protects life in such circumstances where no alternative exists. It might be, in a case of fire or flood, necessary to separate men and women to protect women and children for a shorter period. So can we reach a desirable synthesis between these approaches? This discussion highlights the conceptual impossibility, I would argue, of adopting a strict differentiation approach, which fails to connect housing with other interests such as life. Where we do connect them, though, it is necessary to recognize that the interests in question can have different degrees of priority. In defining minimum standards as a result, we must of necessity relate beyond the sphere of space and structure to the point of having housing. But in doing so, it is possible to recognize a spectrum whereby some interests, such as life and health, may at times take priority over others, such as privacy and cultural adequacy. Of course, the higher level of decent or adequate housing should take account of all of these interests. Situations of emergency and temporariness require developing a ranking of importance of specific interests implicated in the right to housing. A more complex, integrated approach thus is preferable even in situations relating to minimum standards, but must itself recognize a differentiation amongst the interests implicated in the right to housing. Now, I want to say a few words about the situation in Colombia, about the relationship between rights. In Colombia, interestingly enough, the Colombian court was faced with the problem that social rights, there was a question around the justiciability of social rights and the availability of the tutela, because it's not in the fundamental rights section. And this was initially solved by the court in Colombia by the doctrine of connection between social rights and other fundamental rights. And so T49510, for example, dealt with water seeping into the house of an applicant through serious flaws in the sewerage system. The court concludes there that the right to decent housing is intimately connected to the right to health, to life in decent conditions, and to special considerations regarding the constitutional protection of children and older adults, and can become a fundamental right depending on the specific case. In some of the more recent cases, the court has essentially recognized certain social rights as fundamental in themselves. And from what I could understand, the main reasoning for that is because they are fundamentally connected to dignity, okay? And that they sort of rooted in sort of the more abstract notion of dignity. So the Constitutional Court in Colombia had the problem which South African court didn't have of actually giving the justification for why they are fundamental, and it does this through these various mechanisms, and so intimately connected these rights already to other rights, and has in series of judgments also recognized the composite nature of the housing right. If I may, as someone sort of outside from reading the jurisprudence, perhaps one of the challenges for the court here, although it has gone further than most courts in the world, is to define the standards applicable in relation to the various levels of and standards that are available to individuals for different levels of housing and the priorities to be given to them. I found in some judgments a conflation between minimum standards and higher levels of provision. In T426 of 1992, an early case, for instance, there is a mention of survival, but then immediately the higher level standard that everyone must have a free development of their personality. And so I think there may be a need to think through perhaps more cautiously and clearly what standards are available to individuals in particular circumstances. At the same time, there has been an attempt in Colombia through, for example, the famous IDP case, TO25 of 2004, to come up with a composite standard for medium-term temporary accommodation, which to me seems really interesting. And that standard was set as whether the accommodation provided by the government was conducive to the preservation of life in dignified conditions proper to autonomous human living. That standard, if we apply it back into the Dladla case, would have obviated the need for the majority to separate out housing from other interests, such as autonomy and dignity, and in relation to the minority, it would have given greater content than the vague reasonable standard to what is required in giving effect to adequate housing. So in conclusion, I have argued for the importance of attending to the content of socioeconomic rights and the problems in the global south of determining standards for housing that fall short of being fully adequate. I contended that defining thresholds in relation to housing cannot be done by attempting sharply to separate out housing interests from other interests. When we look at these different interests and rights, we may need to prioritize some over others in defining standards for emergency and medium-term temporary accommodation that affect so many in our countries. A right such as a housing right is a composite right that must have reference to other interests in determining its entire content. Providing content to these rights and discernible standards is an important contribution that constitutional courts and other courts can make in ensuring that social rights help advance the poor and the most vulnerable in our societies. Thank you very much.
Gracias al profesor Vilchis. Es un gusto saludar ahora al profesor Octavio Luis Mota Ferraz, es abogado de la Universidad de Sao Paulo, tiene maestría en Derecho y Ética Médica de King's College y es doctorado en Derecho de University College of London. Actualmente se desempeña como profesor de Derecho Transnacional en el King's College en Londres. Profesor, bienvenido.
Buenas tardes a todos. Me gustaría mucho hablar en español, pero como
Speak in Spanish, but as you can tell, my Portuñol is not very good, so I'm going to speak. Since I can't speak in Portuguese, well, I'm going to do it in English, which is the other language that
it's an honor for me
I can speak.
be in this conference. I have been following and admiring the work of the Constitutional Court for some time now, and have had the pleasure of knowing in person two of its impressive judges, Manuel Cepeda and Carlos Bernal, and I'm delighted to have met so many others today. So thank you so much for the invitation, Justice Alejandro Linares. It's a pleasure to be here. The topic of our panel, social rights constitutionalism, and more specifically, the role of courts, is fascinating, complex, and large. I am having trouble to address it in the required depth in a whole 300 pages monograph I am currently writing, which focuses on one country, my own one, Brazil, and one single right, the right to health. To reduce it to a single paper of 40 pages was a challenge. To condense it into a 15-minute talk is simply impossible. My presentation will therefore inevitably leave out a lot of important detail and explanation that I try to develop in more depth, both in the paper and in the book. So the first question I address in the paper is a methodological one, often overlooked, in my view, in this debate. How does one assess, in the first place, the proper role of courts in the enforcement of social rights? I follow an institutional approach rather than a formalist approach, drawing on Canadian scholar Jeff King's helpful distinction. As he aptly describes, the formalist approaches are premised on a formalist separation of powers between legislatures, the executive, and courts. So familiar conceptual distinctions are used in such approaches, such as those between law and politics, principle and policy, and justiciability and non-justiciability. Institutional approaches reject the usefulness of such distinctions and focus. They focus rather on the comparative merits and drawbacks of the judicial process as an institutional mechanism for solving problems. The central idea is that of comparative institutional competence. And by institutional competence is meant the familiar concepts of legitimacy and capacity, which we have heard several times today already. So if the institutional approach is correct, then the appropriate role of courts and other states' institutions can neither be static nor universal. That is, they cannot be determined once and forever and applicable everywhere. They rather vary and evolve depending on how the institutions perform in a particular time and place. So as American political scientist Robert Dahl persuasively argued, in my view, I quote, "It is misleading to suggest that there is one universally best solution to the problem of how best to protect fundamental rights and interests in a polyarchy. Although American lawyers typically assume that the solution must include a Supreme Court with the authority to strike down national legislation that violates fundamental rights and interests, such a system of quasi-guardianship is neither necessary nor, on American experience, sufficient. In the absence of a universally best solution, specific solutions need to be adapted to the historical conditions and experiences, political culture, and concrete political institutions of a particular country." End of quote. So whether social rights should be justiciable or not cannot be decided in the abstract, as if there were a blueprint that prescribed one way or another to be adopted by every single country in the world. Social rights justiciability under the institutional approach I am defending here is a piece in the democratic regime's puzzle, much like the electoral system, the government regime, the composition of the legislature, and many others, whose usefulness and precise design is to be decided by each country according to their local political culture and institutional performance in their ever-elusive quest towards the best possible protection of human rights. So the question is not whether social rights are matters of law or politics, principle or policy, whether they are justiciable or non-justiciable, as we see a lot in the debate. The question is, can courts do a better job, that is, a more institutionally competent one, from the legitimacy and perspectives than political institutions in the protection of social rights? Or can they at least contribute to and not make things worse in the protection of social rights? This, in my view, is the correct question to ask. Now, if this is correct, then the next task is to determine what precisely is involved in the enterprise of protecting social rights. That is, in making them a reality for the population, as David Bilchitz really stressed, where they have been constitutionally recognized. This is because comparative institutional competence of courts, legislatures, and executives is strongly related, in my view, to the nature and complexity of the task at hand. So my next argument in the paper is that we need to realize that social rights are not a homogeneous species that comes in a single shape, as often assumed in the debate. They are rather significantly different in nature and come in variable formulations within the Constitution, and this has an important bearing on our question about the appropriate role of courts. So the rights to social security, to social assistance, and some work-related rights have a lot in common, but are different significantly from the rights to health, education, and housing. These latter rights have some common characteristics as well, but also differ among themselves. These differences in the nature and legal formulation entail different issues in terms of the comparative institutional competence of courts, legislatures, and executives. Some rights will present much lesser challenges for the institutional competence of judges than others. A thorough treatment of this point would require extensive analysis of all social rights and their formulation in a particular jurisdiction, which is, of course, impossible here. But let me give a couple of examples. Take first the right to social assistance recognized in the Brazilian 1988 Constitution. Article 203, social assistance will be provided for those who need it, independent of contribution to the social security system, and has as its aims, 5, the guarantee of 1 minimum wage monthly to individuals with disabilities and to the elderly who prove not to be able to subsist on their own or with the support of their family in the terms specified by law. Now, constitutional provisions of that nature present very little difficulty in the determination of what is required to be done. They invite the exercise of a mere logical intellectual operation. The entitlement guaranteed to the right holder is very precisely set in the Constitution as 1 minimum wage. So this type of formulation, unfortunately, is not the one that is adopted in most social rights in constitutions. Many of them are formulated rather in qualified and vague terms. So good examples, again, of this kind can be found in many of the provisions of the Colombian, Brazilian, South African constitutions, especially in the areas of health, education, and housing. So just as one example, the following provision on housing in the Constitution of Colombia, which I am a proud owner of now. Article 51, all Colombian citizens are entitled to dignified housing. The state shall determine the conditions necessary to give effect to this right and shall promote plans for public housing, appropriate systems of long-term financing, and community plans for the execution of these housing programs. Now, this type of formulation presents significant greater complexity for the determination of the content of the obligation. There are several vague terms within it that require a great deal of specification before one can extract a minimally clear direction about what the state ought to provide to its citizens. What does dignified housing mean? What are conditions necessary to give effect to this right? Now, when obligations are stated in vague and qualified fashion, such as this, the room left for interpretation, determination of the content, is rather ample. And it also often involves intractable questions of social policy design and administration in a context of inevitable scarcity of resources, a point that was very well emphasized by the mayor of Bogota this morning in his rather strongly critical speech. So it seems appropriate from the perspective of institutional competence, legitimacy, and institutional capacity that in a reasonably well-functioning democratic regime, courts are attributed a complementary role and not the leading one in the determination of the specific content of these vague and qualified social rights obligations in housing, education, and health. And this is perhaps a point of fierce disagreement between me and David, and not a new one. There is no precise single correct answer to any of these questions. That is, answers on which a reasonably extensive consensus can be formed. On the contrary, in any modern pluralistic society, people will tend to disagree significantly about them depending on their political and moral outlooks. Views will normally range from fierce opposition to any substantive government investment in any service apart from law and order, policing, national security, courts, to a strong support of large-scale government investment in universal social policies in health, education, housing, social security, etc. And there will be many other views in between. Now, I expect this to be reasonably uncontroversial, not for everyone, but for many. This Colombian Constitutional Court itself emphasized this very point in its structural injunction in the displaced persons case, T25. I quote, the court is not suggesting that the tutela may be used to order non-budgeted expenses or to modify budget planning as established by the legislature. It is not defining new priorities or modifying policies designed by the legislature and developed by the executive. Now, so far, so good. But what we still need to address is a much more controversial question. Even if we agree that courts should not be the primary decision makers in determining the precise content of specific social policies that vague social rights call for, what more precise complementary role are they legitimate and capable of exercising, if any? Now, I call this the court's dilemma, to interfere or not to interfere, in the title of the paper. On one hand, we do not want courts to get involved in the allocation of budgets, design and implementation of social policies. Given their comparatively superior institutional competence, we prefer legislatures and the executive to carry out those tasks. But on the other hand, as these are constitutional rights, we also think that the state should not be totally free to operate however it sees fit. Constitutional rights ought to imply some form of legal accountability on the representative branches of the state. But what exact form? The dilemma, again. It must be one that does not unduly strain the boundaries of courts' legitimacy and capacity. And this is the difficult challenge that so many academics and courts have taken up without, however, so far, as we can see from this conference, managing to reach a stable consensus on an adequate solution. So I hold no pretension, of course, to provide the ultimate answer to this age-old intractable issue. Moreover, as I emphasized in the methodological question above, the appropriate response to this issue is context-specific and therefore requires specific detailed information, discussion, and analysis of particular countries. What I would do instead in this final part of my talk is to go through some potential answers, which I qualify into two camps: extreme and inadequate, in my view, responses to the dilemma, and intermediary and more adequate ones. I emphasize again that I don't think there is a perfect answer to the dilemma. There are better and worse ones, in my view. So I start with two rather extreme, radically opposite approaches adopted in different jurisdictions, found mostly in my research in the adjudication of the right to health. On one extreme, we have a very differential response in which judges should simply refuse to interfere at all with decisions made by the representative bodies on grounds that they lack legitimacy or institutional capacity to do so. Now, this extremely differential approach, which is perhaps what we see in the place where I currently live, the UK courts, if adopted too strictly, risks conceding to the representative branches an almost unlimited discretion in relation to implementing social rights, which would sit uncomfortably with the expectation that rights ought to entail some measure of legal accountability that I emphasized before. So are courts not abdicating one of their main roles when adopting such a differential approach? I think this is Bilschit's, perhaps, a strong point. On the extreme opposite end of the spectrum, we have a rather assertive approach in which constitutionalization of social rights is seen as a sufficient mandate for judges to interfere strongly with the decisions of the other branches whenever these rights are engaged, having little concern, if any, about a potential lack of legitimacy or capacity. Judges who adopt this assertive approach tend to believe, contrary to what I've argued, that the constitutional social rights provisions are sufficiently clear to enable them to adjudicate the social rights cases that reach their courts without any problems. Such approach can be found mostly in some Latin American countries, and the most extreme is perhaps to be found in my own country, Brazil, in the right to health jurisprudence, but it's also raised its head elsewhere, including Germany recently, I have heard. Now, what about intermediary, more adequate responses? If these two extreme approaches are inadequate, are there more appropriate intermediary ones, or are we caught between abdication and usurpation, to use Frank Michelman's evocative formulation? Some responses have been attempted from academics and courts that fall somewhere in the middle of the spectrum, and they can be helpfully, even if somewhat artificially, classified into procedural and substantive ones. Procedural responses see courts as legitimized and capable of exercising an important role in guaranteeing the fairness of the process of decision-making by legislatures and executives when they specify and implement the vague social rights clauses of the Constitution. The most familiar formulation of a substantive approach is probably the so-called minimum core, sometimes referred to as the existential minimum, or minimum existential, that we heard a lot from David Bilschitz, so I won't repeat his very detailed exposition. So in my view, the minimum core approach certainly has some intuitive appeal, but it suffers from several significant conceptual and pragmatic difficulties. It is doubtful that determining the minimum core will indeed evade the intractable decisions about resource allocation and policy formulation that social rights involve, in particular in middle income and developing countries, which is our focus. So once these difficulties with even a minimalistic substantive approach are highlighted, procedural approaches start to look more and more like the only appropriate ones for courts to adopt when enforcing social rights that are formulated, I emphasize, only those that are formulated in vague and qualified terms, like the rights to housing, education, and health care, not all social rights. There are many social rights that are very easy to implement. Now, the Colombian Constitutional Court seems to apply a hybrid procedure and substantive approach For instance, in T7060 2015 on the right to water and to housing, it applies a substantive approach to the right to water and a procedural approach to the right to housing. Now, to finish, when I suggest that in social rights cases, courts ought to refrain from interfering with the substance of decisions taken by the legislature and the executive, I will certainly please many, like the mayor of Bogotá, Senor Penalosa, this morning, but it also raises, I admit, a concession to David Vilchitz and many others, justified concerns that this may not be an appropriate way in which to protect fundamental rights. If these are real rights, it will often be argued they deserve some measure of substantive protection from the courts, especially, again, in developing countries when they are more frequently disrespected. So as my colleague and present here in the panel, David Landau, has forcefully put in an excellent recent paper, I quote, "Systematic failures in both legislative and bureaucratic politics in developing countries make dialogic approaches unlikely to work in those countries. The intended recipient of the dialogue is unlikely to respond effectively. There is a desperate need to innovate with aggressive remedies if social rights are to live up to their transformative promise." This is related, I think, to Gargarella's idea of defective democracies, right? So it is a real dilemma. Like, if these institutions are unlikely to respond to a procedural approach, it seems appropriate to try a substantive one. So it's true, as I considered above, that procedural review cannot provide as assertive a protection to social rights as we have become used to expect when fundamental rights are at stake. When someone is found to have been arbitrarily imprisoned, for instance, we expect the courts to order their immediate release. If someone is illegally prevented from registering to vote, we expect judges to issue a positive injunction ordering their prompt registration. If it is proven that a detainee has been tortured by the police, we expect the judiciary to condemn criminally the public servants involved and the state to pay the victim compensation. But I believe that rejection of the procedural approach rely on intuitive assumptions like this that may not be on reflection entirely warranted. It might underestimate both the capacity of political and administrative bodies to interpret and implement in good faith their constitutional social rights obligations, and also the potential of procedural review to provide meaningful legal accountability. It might also overestimate the potential of substantive judicial review to protect fundamental rights and ignore its potential to generate negative effects, as in the Brazilian right to health case, which I've been studying for a decade now. There seems to be no reason to believe that courts will be more competent in the monumental task of implementing social rights than its political counterparts. However much beset by systematic failures this might be. I think this is a point that Professor Marmor made earlier. So it seems also a bit too optimistic to expect that failing political institutions will implement obediently and effectively the policies that courts come up with, which is the ineffectiveness issue that all constitutional assertive courts face across the world. So to finish, procedural review of the decision-making process of representative institutions, if performed well, can help improve both the quality and the fairness of that process, which is by no means an irrelevant contribution for courts to make in democratic regimes, which I think was Gargarella's point as well. The procedural parts of the Colombian right to health T760 case seems a good example. So as the American political scientist Robert Dahl insightfully stated, I quote, "The democratic process is a gamble on the possibilities that a people, in acting autonomously, will learn how to act rightly." End of quote. Judges ought to be an integral part in that enterprise, not the guardians that will purportedly save us from our mistakes. Thank you very much.
Gracias al profesor Mota.
Thank you to Professor Monteferres. I remind you that you can send in your questions by way of the event's web app at webapp.corteconstitucional.gov.co. Before starting with the discussion, we will hear from Professor David Landau. He's an attorney in political sciences from Harvard University. He's currently the Dean for International Programs at the School of Law at Florida State University, and is also a Mason Lab professor. Welcome.
Bueno, gracias a la Corte Constitucional y a su presidente, Magistrado Linares, por esta invitación.
Judge Linares, for this invitation. It's a great honor for me to be part of this panel with 8 very well-known academics on social and economic rights. And as the others, I will give the rest of my presentation in English. It's probably better for everyone.
I'm going to speak now on remedies for social rights violations, or on the orders of the court in a social rights case. And the jumping off point for the paper on which I am basing my talk is a recent paper by a very well-known Canadian scholar, Kent Roach, on what he calls two-track remedies. So Roach's observation is that courts around the world commonly issue 2 kinds of remedies when they find violations of law. Simple remedies and complex remedies. Simple remedies seek to resolve the legal problem for the precise petitioner in the case in front of the court. So, as we know, we've had many examples from Colombian jurisprudence. In a case on the right to health, for example, a simple remedy would seek to give the petitioner something like access to treatment or access to medicine. That precise petitioner. What Roach calls a dialogical or complex remedy is a remedy that seeks to deal with or an order that seeks to deal with a bigger issue in some sense, seeks to deal with a larger social problem. Usually such remedies are dialogical in the sense that they aim to develop more effective public policy in conjunction with state authorities. So the argument of Roach, which again I find very provocative and very useful, is that on major issues, when courts find violations of major issues, they should usually develop a two-track remedy, because each type of remedy rather, responds to a different intuition about judicial role. The structural remedy deals with the fact that one has a very complex political or social problem which can't be resolved simply by issuing a bunch of individual orders. The individual order gets at a different intuition, which basically is that courts are a certain type of institution, and when an individual goes to a court, they ought to be, and the wrong is found, they ought to be able to get a remedy. Right? So the idea of sort of court-likeness, which Roach argues affects the legitimacy of courts, the legitimacy of justice systems more broadly, an idea of justice in some sense. Roach, I think, notices something important, which is courts often do act this way, and that both types of orders have a somewhat different rationale. One of the central examples, in fact, in his work, is the social rights jurisprudence of the Colombian Constitutional Court, where he argues that you can see both of these dynamics present, sometimes, for example, with respect to the right to health, on the same issue. So I think that, Roach's insight is general. He's talking about all kinds of cases, all sorts of remedies or orders for violations of constitutional principles. But it is interesting that one of his central examples is social rights, which I think, and I don't think anyone on this panel will dispute it, raise some of the most difficult problems of judicial enforcement. Trying to craft an order is particularly difficult for a social rights violation. The critique of Roach's point that I want to develop here, or sort of build off of here, is that the right kind of remedy is contextual. It depends on key features of the political context. And the ideal court would be responsive to those differences in political context. That the theory of remedies that we want to develop for social rights cases is a theory of the responsive court, in essence. A court that behaves differently depending on the kind of social and political problem or situation that it's confronting. Thus, I think we need to disaggregate Roach's claim and consider the possibility that there are two-track problems where a court wants to issue both remedies, both kinds of one-track problems where you want just a set of simple orders or just a set of complex orders. And perhaps in the extreme, although I think it would be very rare, there's at least a theoretical case for a kind of no track, in essence, a case where both kinds of remedies are going to function poorly. So one question, I think, one key question is when a systematic remedy or systemic remedy is the best response to a social rights violation. Some sort of stylized facts, I think, that one can take out of the literature. We do know that structural remedies can be effective. We don't have a huge database of cases, right, of these sorts of remedies, but we do know that they can work. They can be cases. They can be effective, and this is particularly true in cases where the failure of social policy is large scale, where there's a pretty significant failure of social provision or the bureaucracy with respect to a problem on social rights. Structural remedies in those sorts of cases, or dialogic remedies or complex remedies, show the most promise in potentially making progress in producing bureaucratic change. They also perhaps show the most promise in reaching sort of the most marginalized groups within the population. So it can be more difficult with respect to individual orders, I'll talk about later, to actually reach the marginalized, because you're dependent on who actually shows up and sues. So I think there's a strong case for using structural or complex remedies for enforcing socioeconomic rights. We also know that they seem to work best, at least in the cases we have, as Cesar Rodriguez Garavito has written, in cases where they're accompanied by a monitoring mechanism, right, where you don't just issue structural orders, but you also have a fairly complex monitoring mechanism that goes along with them. And these, of course, existed to different degrees in some of the very significant Colombian constitutional court cases that were complex cases. The internally displaced persons case from 2004 and the health case from 2008. The problem then, right, if we know that these things work well or can work very well, the problem, I think, under current remedial design, at least current state of knowledge, is a sort of scarcity problem in a sense. That there's a strong case for structural remedies in many contexts where you have pervasive failures, but it's difficult to issue a structural remedy and to do so well. They can potentially tax the capacity of the court. They can be quite expensive. They can raise concerns about backlash against the court. And it's also true, I think, that in contexts where you often have pervasive social rights problems, if one can say loosely global South context, the form of complex remedy that you're forced to come up with is a relatively costly remedy. Not all complex orders are costly. There are some that could be, in fact, quite easy to give. For example, you could simply issue an order asking or ordering the legislature to change the law in a given area. But I think, generally speaking, when you're talking about problems with social and economic rights, that sort of an order is not likely to do all that much, and it's particularly not likely to do all that much when you're dealing with kind of pervasive state bureaucratic failures. In other words, the easiest kind of complex orders to give are not likely to be effective, and the types that are likely to be effective raise what I do think is a significant sort of scarcity problem, right? So I think, to me, that raises interesting questions that one might call sort of agenda setting. When is a complex remedy the appropriate response? And there are various factors that bear on that. One is the severity of the problem, obviously. How pervasive is the state failure in a given area? Courts have information here, right? One source of information is their own dockets. If you're getting a lot of cases in a given area, it gives you some sense that there may be a significant problem. And this is built into doctrines like the Colombian Estado de Cosas Inconstitucionales, which have as a kind of piece of the doctrine, is this something that's starting to overwhelm tutela dockets, for example. But it's important to recognize as well that those sources of information are incomplete, right? That they can be distorted in certain ways because it may be, for example, that only certain people are getting to court. And severity of the problem, of course, is only one factor. There are also other questions that I find more difficult surrounding the political context. One of which is, given that complex remedies are a kind of scarce resource, one must think about the likelihood that a given intervention will be successful. In some sense, the marginal gain of a given structural intervention. And this, I think, depends on the political and legal context surrounding the intervention. There are almost certainly cases where there are huge bureaucratic failures, but the court's ability to do a lot about those failures may be limited because of political resistance, lack of civil society support. And so the tricky thing is, I think courts, as part of a conception of role, must build in the surrounding constellation of political forces. And this is particularly true for structural orders. And this is something I think, at least implicitly, was part of the calculus with respect to these two major structural cases that I referred to before. So what I conclude essentially with respect to structural orders is that there are cases where a court has something of a duty to issue a structural order because it will produce the greatest gain, in a sense, in constitutional compliance. But that you can only identify these sort of cases based on a combination of factors, severity, cost, political support, that are perhaps a little bit outside of what one thinks of as a standard conception of judicial role. I think there are other implications of this point as well. One is that I think there is really a significant need to innovate with respect to complex orders in ways that may reduce or ameliorate the scarcity problem. To try to figure out ways to do things like monitor that are not as costly in terms of the resources of the court as the sort of full-fledged monitoring process that existed in the Estado de Cosas Inconstitucionales cases. And I think there is room for lots of innovation here, right? There are ways one could think about different kind of orders that either, as has happened to some degree, put the monitoring costs on other actors, right, or otherwise sort of ameliorate that sort of a problem. Because if the best solution often is a complex structural order, we've got to figure out, I think, how to do that in a way that is sustainable given the resources of a court. And I don't think it's an impossible task. It is a very difficult task. Another question, I think, again, raised by Rocha's basic typology between the complex and the structural, sort of the opposite question. When should a court only work on a structural track? When should it essentially cut off the simple track? Normally, I think courts leave both tracks open. An example from the Colombian context, if you think about it, is T760 of 2008, where the court issued a structural order which reduced the individual tutela jurisprudence of the court to some degree, but it was still there, right, and still played a very significant role alongside the structural order. Individual or simple remedies, I think, do play functions that are valuable within a legal order. As Roach argues, they provide a sense of court-likeness, right? They provide a sense you can actually go to a court and get a remedy if you have identified a wrong. And this affects, I think, the legitimacy of the court and also, in some sense, the legitimacy of the system with which you're dealing. If you have pervasive failures of state policy, there's something to be said, and I think there has been something very important to be said for the constitutional history of the Colombian Constitutional Court, for being able to go to a court and get a remedy in the face of significant failures of systems of social provision. But I think there are also cases, there are also problems with individual rights jurisprudence that suggest in some cases you ought to tell litigants essentially, we're dealing with a problem in a complex way, in a systematic way, in a dialogical way that will take more time. And as a result of that, we're not going to issue an individual remedy to you in this case. And those, I think, are cases where issuing individual remedies can make the performance of the system worse or increase distortions or introduce new problems within the system. So there are cases, I think, where systems of social provision, if you allow individuals to seek individual orders from the court, you actually in some ways are distorting the overall functioning of the system. There are also, of course, as I referred to before, equity effects at times of individual jurisprudence. You have to think about who is actually suing, right? Even with respect to as simple a mechanism as the Colombian tutela, it's still true that these equity effects, I think, exist in certain contexts. And finally, you need to think about the possibility the individual orders cut against what you're trying to achieve. So it could be that issuing a lot of individual remedies actually takes pressure off the state to come up with a large-scale solution. The most obvious way this would happen is if influential people or those who would have power to influence public policy are able to get remedies or orders, solutions to their problems with an individualized jurisprudence, then it may take a lot of pressure actually politically off the state to come up with a systematic solution. Finally, so I've dealt with sort of the other three boxes, a kind of two-track, only a complex remedy, only simple remedy. Most tentatively, the idea of a no-track remedy. There are conditions where a court should say, we think there are social rights violations here, but neither track works. And I think, let me tell you something about social rights that at least theoretically, there may be such a case. I hope that these cases are rare, and I find them deeply troubling, but I think if you follow the analysis, at least theoretically, there may be cases where this exists. Again, you have a sort of scarcity problem, or you think a complex remedy is unlikely to achieve much, it may not be the appropriate remedy. And along with that, you might have cases where individual remedies can worsen systems of social provision rather than ameliorate it. If those two conditions ever go together, then it might be the case, right, that a court should say there are serious failings, social provision here, that are violations of social rights. But it's not clear that at the moment we have a response. Now, I find that possibility painful, right? I think it's very problematic, and I'm not sure what a court should do if it reaches that conclusion. I think one should do everything you can not to reach that conclusion, but I think theoretically it may exist. What's the kind of broader point, finally, to conclude of this sort of typology? There's a burgeoning literature now on social rights. We know the contributors to this panel are examples of it. Some of that, a lot of that work is on interpretation. Some of it is on remedies, and I think the comparative literature has added a lot to our understanding of what's going on from a remedial perspective. We have a number of examples drawn from different contexts, places like South Africa, India, Brazil, Colombia, which has been an incredibly important example in comparative terms, which scholars now routinely draw. But the literature on remedial design perhaps has not advanced enough between the stage of sort of suggesting what the possibilities are, kind of experimentalism, and a more guided set of factors of what the appropriate remedy is in a given case. And I think that's problematic for two reasons. The first is pragmatic, that there's not enough guidance, I think, given to judges and others about what kind of remedy should be given in a particular social rights case. And the second, of course, is that the remedy is intertwined with the right, and perhaps in some sense, I don't want to raise big debates that are very problematic, but in some sense, you know, obviously if you have a right and you don't have an effective remedy, it doesn't really matter what the interpretation is. So the remedies matter immensely, and I think we do better at building up not a science, but more systematic knowledge from our comparative experience of what kinds of orders make the most sense in different kinds of contexts or different kinds of violations. And so to conclude by answering, I think one of the questions that was posed to us, What should the judicial role be with respect to social rights is not a question one can answer universally. You can't answer it with some broad doctrine, for example, the separation of powers. Courts do X, they don't do Y. You can't even answer it with respect to countries. In a given country, this is how enforcement should proceed, or issues. The answers here, I think, inevitably depend on aspects of the political context that vary across country, issue, and time. And the ideal court would be responsive to those differences in ways that I think have not yet been fully recognized in the comparative literature. Here, I think the Colombian jurisprudence has made probably the richest contribution in the world to the field of comparative constitutional law and social rights more particularly. Thanks.
Gracias al profesor Orlando.
Thanks, Professor Orlando. Now we would like to greet Dr. Elena. She's a lawyer from Addis University with a master's degree in gender from Harvard University. I would also like to greet Mr. Uprimi Yepes, who is a lawyer from External University with a master's degree in sociology and development from University of Paris with a doctorate degree from Amiens University. They will be the commentators for this panel. I would like to greet you. You may start now. Well, good afternoon to all of you. After all these very interesting presentations, we are going to offer some comments. I will be moderating this section of the panel. I am Elena Alviar, as you already saw, and I'm very grateful and also very honored to be in this panel with such important experts and to be the only woman in this panel as well. I am going to give the floor to Professor Rodrigo Uprimi, who will make opening comments, and then I will make closing comments, and after that I think we're going to, and then we'll give the panelists an opportunity for them to answer to the different questions in a way, and if time allows, we will look at different questions from the audience. So, Rodrigo. Good afternoon to all of you. I'm going to start off by clarifying that this voice is not to put more suspense to my presentation. It's just that I have laryngitis, a very strong laryngitis that almost impeded me to come to this session. But we don't deny anything to the Constitutional Court. So it's a pleasure for me to share this panel with academics that I respect a lot. I don't always share what they say, especially Octavio. We have always a controversy with him. And to share with Elena, who I have a very tight friendship with. You have heard 4 excellent presentations. We've also read 4 excellent texts, documents, if you will. These are documents that are very different from each other, both on the issues that they talk about, as well as the different approaches and visions that they have. To an extent, the documents from David Vilchitz and Axel Chencher, their last names are harder than mine to pronounce. These are texts that move more around the dogmatic approach or the constitutional doctrine. What they seek to do is determine the content of social rights or methodologies to address the contents of social rights and to determine when a violation happened or not. David referred to the debate from the South African jurisprudence, especially in this last case that he mentioned, on if it's better to have an approach that emphasizes on the differentiation between the rights, or on the contrary, there should be an integrating vision in terms of rights, referring to the rights of housing and adopting that stance. And what Axel does is a criticism from the German jurisprudence and from the Swiss Federal Court. This is criticism to better understand the social rights with the methodology of the principle of optimization, closely related with Robert Alexei, that would lead an excessive influence of courts in terms of social politics, and defends an approach or approximation by way of a methodology of balance, imbalance, ponderation, but without any optimization. Now, Octavio Ferraz's text is quite different. It doesn't move around the dogmatic part, instead the politology or the institutional approaches to address the capability or the capacity that judges can have and the constitutional courts can have at a comparative level with other democratic organs such as legislatures, executives, or technical institutions, and to what extent they have more institutional competency to protect social rights. And reaching a conclusion where that depends really on the types of rights, and it also depends on the contexts, and that in some they could be adequate, in some others these could be highly problematic. And in the middle, we have the text of Professor Landau, David Landau, who analyzes, as you saw, the issue of remedies, which is the point that puts in connection the rights with the institutional contexts. If we should privilege simple remedies for individual cases or more complex remedies for collective cases by way of processes that some have referred to as jurisprudence. Depending on the vision, you might be closer to the position of Ferraz, where this will actually depend on the types of rights, the contexts, and it wouldn't even be worthwhile for the national context. Well, it would be better for this structural remedies for these cases, and for others it would be individual remedies or a combination of these two. But it's not just the topics that are different, but also the approaches are somewhat different. There are approaches that are somewhat much more normative, if you will, such as the case of David from South Africa and Axel from Switzerland. These are analyses that are more proper to the theory of rights and constitutional law. Others that are, let's say, have to do with much more empirical economy with Ferraz, and others right in the middle with David Landau that combines the remedies. Every time I talk about my remedy, I remember my laryngitis. But this has to do with violations and the context. So of course, for Elena and I, the quality of these texts, but as well as the diversity. And lastly, there is an awareness that was clearly expressed by Octavio and David, who is much more, sympathizes much more with judicial protection of social rights, while Octavio Ferraz has been a critical person. So these texts are quite different. In that context, for a commentator, it's very difficult to make comments on such different texts, and I can stop at that. To say it was very difficult work, I'm gonna go rest my voice here with my laryngitis. But instead, I'm going to try to make an effort, because those texts, despite being so different, they have common elements that are very important. Because the people that have different positions, that work on different matters in a same area, if they reach common points or elements, I think that is a significant piece of information. And despite the difference, these texts have many elements that are common that I would like to highlight. The first one is that they all recognize the reality of the social rights and their justice. We are not, as it happened 25 years ago, for those who lived back then, in a debate as if whether there should be the way of justice. That debate, it's not that it doesn't exist. Arguments in favor and against them are still good debates. These still have good arguments, but those arguments should happen in the face of the reality of justice in social rights around the world. And not just in the constitutional world, but also in the world of international law of human rights. As you know, I'm a member of the committee of the UN, and for 5 or 6 years now, the power to present individual cases and collective cases before the committee is enforced. We have received over 20 cases, and 4 have already been solved. So there is a reality of justice in terms of social rights at an international and local levels. And this debate should be done regarding that empirical material, and I believe that the four authors are aimed in that same direction. Now, the second thing is that they recognize that in that there is what we call, there's a diversity of forms and intensities in terms of the intervention of judges in the protection of social rights. That is, when we talk of justiciability of social rights, we're not talking always about the same thing. One thing is that a constitutional court establishes that you have to provide with a decent housing to all the population. This would be of justiciability. And another one to say is that I'm going to control housing policies to assess their reasonability, which is what the South African court has done, which is a different way of justiciability and social rights. And all the authors recognize that there is justiciability that are different in forms and intensities. And that, of course, leads the four to a third conclusion, which is what we could call a type of intermediate assessment. That is, if we were to ask them, what do you think about justiciability of social rights? I think that the four would say, as Cantinflas would say, well, this will depend. Well, there are some good ones, and there are some other ones that are bad. Some that can be criticized, and other ones that have showed positive results. For instance, Axel heavily criticized the way as to how the Constitutional Court from Germany defined the floor of the taxation, and I think that this is assertive, as well as Ferraz, who has been very critical on the jurisprudence in terms of the protection to health in Brazil by way of individual cases due to the regressional effects that this has had to the extent in terms of the people that have had access. This has been middle class and not high class, and not the lower sectors that have been excluded. So we could criticize certain ways of justiciability, but this doesn't mean that one criticizes just in a comprehensive way, where judges intervene in terms of protection of social rights. I would believe that that is a common stance. Then comes the first question for Octavio, if he would say that is an adequate way to interpret his position, because that would be a variation of a tone in the face of other previous texts, where he would basically say that judges should not get involved in the protection of social rights. I think that in this text, this has been toned down. He would almost seem to say at the end that this is part of a minimal democratic element where there is a way of justiciability of social rights. The debate is that we have to see where there is more justice for the judges to do them. So in that sense, and that is the fourth common element, the four texts are what we could call constructive criticism. So starting from those experiences of justiciability in different parts of around the world, they try to advance, critically speaking, saying, look, in these cases, you should resort to structural remedies. In these cases, you should resort or you should keep individualized remedies. In these other cases, you should understand social rights in a comprehensive fashion, articulated to the set of rights. In these cases, you may prefer a form of protection that is much more, that is less substantial but more procedural. And so there are hints in terms of work and reflection on social rights, both for the academia as well as the judges, that I believe are important. And to wrap up, I would like to, after having shown those similarities, to attempt to, once again, and also by highlighting certain differences, I would like to cause some sort of dialogue among the speakers. So the first question is the following. Well, I think that amongst the four of you, there are two that are much more abstract and other ones that are much more contextualist. Ferraz and Landau would be much more in the context. So to resort to something else would depend highly on the context. What is good in one case, like a procedural thing, could be bad in another case. What is good in one case, a structural remedy, for instance, could be bad in a different case. So my question would be to the other two that have sustained or kept a generalist stance or pervasive stance, not focused on the context, such as David and Axel, if that call to context wouldn't alter your visions or views. In the case of Axel, for instance, where you would have to abandon the theory of rights as mandates for optimism in the case of social rights, or if that is a theory that is insensitive to the context. In all the contexts, it is a wrong one, and same David Vilchitz. And if the idea of integrating approaches are done independent of the context, or is it also an analysis in terms of the context? And I also asked the question, and there's another question from the contextualists to the generalists, let's say. The other question would be the other way around. If the contextualist, if you want to talk about when a judicial protection is much more adequate in terms of institutional competencies, in the case of Ferraz, or in the case of the type of remedy, in the case of Landau, if in any case that doesn't require a prior reflection that is much more abstract, that is much more cross-cutting to the different democratic regimes in terms of what an adequate judicial protection is. So if that doesn't a series of assumptions implicit in terms of norms and theory that should be explicit, to say that a judicial protection should be one that preserves democratic freedom from the to the point where it's possible without interfering in it, that guarantees that the most vulnerable populations don't see their rights, their social rights minimized. And if that would not require a more abstract and theoretical elaboration, let's say. And if that should not lead, and with this I now finish, this should not reach a series of, to the development of a series of methodological and dogmatic tools that could be common to different contexts but used in a different way. For instance, the debate on the content of rights and as a mandate of optimization, if you link it to the debate on remedies, it might be that sometimes the problem does not reside in the way as to how judges build the violation of a social right, but instead there is a mechanical trend to say, since there is a violation of socialization, there's an automatic, we automatically follow a remedy, as David said. But if sometimes, in some cases, it shouldn't go around in a situation where judges declare a violation, and after declaring that violation, they open up to a political debate for a remedy, which would be the way as to how it was done by the Constitutional Court in T025, where they declared unconstitutional things, and to tell the executive, well, solve it. And this is a complex matter. I can't solve it, but this is unconstitutional. And sometimes those statements, even though no specific remedy is followed, but instead this has very strong political effects. And of course, this is something that I say influenced by my work in that committee, where we can't offer orders, but instead only make statements or declarations that are just recommendations. So one likes to believe that what one is doing is important. And now, when I start declaring or stating things, I believe that it's important as what is imperative or coercive, because this opens up to political discussions. And this way you harmonize the protection of rights with the strengthening of democratic deliberations. And I leave now the mic to Elena. Well, it's very difficult to follow up on this, but the general topic of the panel is in reality, and the way I understood it after reading the papers and after hearing or listening from the speakers, is the relationship between bureaucrats, legislators, and I would frame the questions. These questions are under that very broad topic, and they want to answer to a very specific question. And please, panelists, I apologize because maybe I'm going to... There were some presentations that were very complex, and I'm going to try to reduce them to very small phrases or sentences. And of course, if I make a mistake, please let me know. But the fundamental question would be, where, how, and with what intensity should a court intervene to grant economic, social, and cultural rights? I think that is the question, or those are the different questions. And there's a general comment that I would like to make on this as to how questions were asked to the panel, where they used the phrase judicial activism. That also brings in a type of venom, because if you say judicial activism, means that the judges are doing something beyond their scope of work. This is more a characterization that has been loaded with, with an issue, let's say, and not necessarily we all think that there is a problem there. And the answers from the panelists, and on this, in certain topics, I agree with what Rodrigo said, and maybe in others, there might be some differences, but I think two of the panelists believe, and I agree with Rodrigo on this, the debate around if these can be justiciable or not has been overcome. I think there are two panelists that consider that courts should make them exceptional, and there are two that believe that the courts should do it much more frequently, so I'm going to move on to that. For the first panelist, Alex Chechner, I'm not sure if I'm pronouncing this well, but the answer is that the courts should do it very sporadically, with very little intensity, and in individual cases and not structural ones. For David Bilchitz, the courts should do it frequently, and specifically in the global south that has been characterized by great levels of inequality, where the only way, or one of the very few ways through which there can be an improvement of this inequality could be by social and economic rights. However, for David, what is important is how the content of these rights are established. And in his presentation, both in his presentation as well as in his written work and in his paper, he showed that the idea of economic, social, and rights can be separated or can be isolated is a fiction. And there is a connection between the right to health, the right to housing, the right to health, to human dignity or privacy. An essential question there would be, or that he asks and poses, and as he did in his presentation, is how do you select, or how can you weigh in what rights are going to prevail when something comes up related to the right to housing. For the third panelist, Octavio Mota Ferraza, who I have known for quite a while now, the courts should do so, but very carefully, taking into account who has been legitimized to make a specific decision. That is, that the courts are not always legitimized to make that decision, and who has the knowledge, or what in his work calls capability or capacity. Who has the legitimacy and the technical capability to do it better. And ultimately, and of course Rodrigo also mentioned this, he criticizes the intervention of court, and the work in terms of the right to health is very relevant in terms of what Octavio does, showing that sometimes the remedy is worse than the disease itself. For David Landau, the fourth panelist, David maybe will make some clarifications here, but he believes that the court should intervene, but they should be fully aware, and this is one of the most interesting things of his work, in terms of the political context that it's being done in. So this is work that calls on pragmatism. In a sense, he reminded me of a phrase in the Constitutional Court in Colombia, and that the first duty of the Constitutional Court in Colombia is to exist and start from there. And David, in a way, says there are moments where the Constitutional Court should refrain from intervening in a case if they consider that they will put at risk the existence of the court itself due to reasons that are much more pragmatic. And in that sense, he also refers to the issue of the context, as Rodrigo mentioned. But in the case of David, it's much more a sensitivity of the moment, in that specific moment that it happened. And among other things, for the courts to be able to prevent a backlash against not just the same court, but also the policies that are being designed by the court.
So I've grouped the panelists that way, but I think that, well, you might say, no, you're right, you're wrong, but I'd like to pose then two very simple questions, but mostly because of the fact that the auditorium has been here for quite a while now, and I always think that it's good to reformulate ideas that have been stated previously to enrich them. So for the two critics against court intervention, Axel and Octavio, one question that I've always thought of is what happens when legislators or the executive branch is not ensuring rights that are in the Constitution and that the government must uphold. So the question is, well, if the court says we will not intervene, then these are just rights on paper, in a sense. And for the defenders of a more protagonistic role by the courts, how could you avoid, first of all, that Congress not act, which is something that happens, I think in Colombia it's happened many times, where Congress decides or prefers to not act and waits for the court to step in, and the court would assume that political burden of being involved in a certain issue. And on the other hand, well, obviously, in several of your papers we can find this, the court has major deficiencies or shortcomings. I mean, they have great people working with fully committed and everything, but they have institutional and financial shortcomings, which makes it so it's very difficult to intervene, no matter what good intentions there might be, as far as the effectiveness around rights and resource management that would lead to adjudicating such rights. So I'll just leave it there. I will give the floor to the panelists, I think in the same order in which you presented. And then we can see if there's a few minutes in the end for Q&A from the audience.
Thank you very much, Rodrigo and Helena, for this really excellent analysis of our papers. I think you really went down to the details and dug out commonalities and differences which we have not seen before. So thank you very much for that. Now I face three questions and at least one misunderstanding. But I'll start with something Rodrigo did, comparing my paper to that of David Bilchart's. I think you're right that we have both a pragmatic approach. So I'll start with a commentary on David, who was calling for the court as a standard setter. And this is certainly correct. But in my view, there are two very different kinds of standard setting. One standard setting is for the limits, and that's the domain of the court. And the other standard setting, that's like political activism, that's like making guidelines for political leaders how to act in the future. And this, in my opinion, is not in the domain of the court. I would like to recall the famous jurist and the inventor of the Constitutional Court as it is today, Hans Kelsen. He famously characterized judicial review as negative lawmaking. So it is lawmaking in the sense that constitutional courts are political bodies, but they are negative in just setting limits. It's not their task to be positive. So how does that relate to, for example, the kinds of remedies? Rodrigo, you mentioned that my approach was possibly not flexible according to remedies. I think it is, like Hans Kelsen already stated, all kinds of remedies are possible, individual remedies, structured remedies, complex remedies, even systemic remedies. For example, if you declare a statute for specific reasons for unconstitutional, that's very systemic. It's not just an individual action. So I think the approach is open to different kinds of remedies. And it is also, to answer another question you posed, it is also open towards context. If you think about contexts, one context we always have to take into account is, are we in the sphere of reasonable tests, proportionality tests, or have you already hit the ground with the minimum core? So this is highly context sensitive. Once we start talking about human dignity, we're hitting the minimum ground of protection, and then there's no balancing at all. And even within this sphere of of the proportionality test, we have balancing, and balancing is, of course, context sensitive. So in my view, the approach is the approach that really tries to that really tries to cut back on optimization by keeping up the concept of laws as legal principles and proportionality test. That concept is open as well as to different kinds of remedies as to different kinds of contexts. There is one critical question at the end of your presentation, Helen, that is, how can we at all enforce social rights if we are reluctant in the implementation? Actually, I think a court that by simple steps sets limits to the lawmaker without giving guidelines for the future can be very effective. It's just a matter of time and of interaction. And that, of course, is dependent on which country you're in. When you're in a very law-abiding country where the legislator follows up on every constitutional court's decision immediately, like it is in Germany, it's basically the legislator is like a slave of the court by now. Then, of course, you can be very effective. It might be a little different in other countries. Thanks.
Thank you very much as well to the commentators for their very important questions and summaries, as well as to my fellow panelists for very stimulating interventions. Let me say a few things. The first thing is, and I suppose I should say very strongly, I see social rights as rights. They're human rights. They're fundamental. They're no less fundamental than a right to free speech or to fair trial. They are central. If you lack food, if you lack housing, if you lack healthcare when you're sick, you're in a terrible situation. And essentially what's happened in the world is that there's been, for economic reasons and for the protection of essentially the interests of the wealthy, these rights have been regarded as lesser. And a lot of the debates we're having today about why should courts intervene or not intervene is because underlying it is an ideology that these rights are somehow lesser. They don't deserve to be given effect to in the same way as fundamental rights. Ultimately, these are absolutely critical interests that human beings have. And if there is a deficiency in the institutions of democracy, there is a right of another institution which has been given to safeguard those, the police democracy to intervene. And essentially, the task facing these courts is not so different, right, from the task involved in South Africa. We have a big debate today about what is the limits of how do we determine what is hate speech or not hate speech, what is permissible speech or not permissible speech. Why is that so much more? This is difficult. It's not a simple thing to do, right? There's lots of disagreement about that, right? And why is it so much more difficult to determine whether something is a minimum level of housing that's necessary or even adequate housing? I teach constitutional law sometimes to people in poorer areas in South Africa, and I ask them, what is an adequate house for you? Right? And their vision of an adequate house is not very different to my vision of an adequate house. It isn't necessarily a luxury house. People are very careful about specifying it, and when you start laying out the fundamentals, it's quite possible to determine standards, and it's even easier, in my view, to determine standards of minimum levels necessary for survival. So although I don't say there's some level of fuzziness, that there's some level at which people have some disagreement, I think this is overstated in some of the things that we've seen. And I think that you can get, in Europe, there are subjective ways of doing this. For example, I've met economists who go around and ask people, what is a minimum bundle of goods that you would see as adequate? And they are able to quantify and determine those things and actually provide then a notion of what is a decent social minimum. Now, so I should mention briefly a few things, and I'll respond to the questions. The one is procedure. Is it important to have procedure and procedural approaches like Octavio mentioned? I don't disagree. This is very important. The South African Constitutional Court has done important work in ensuring that people whose interests are ignored, for example, are listened to. And let us make this point very importantly. Democracy fundamentally, institutionally, often underrepresents the interests of the poor. The people who are in democratic institutions often are not the people who are in the shacks, okay, who are in terrible conditions. And so there is a fundamental representation gap in democracy. So we need to grapple with that issue when we are dealing with these kind of questions, and providing power to those people who are poor in their negotiations with the other branches of government. What the Constitutional Court in South Africa has called meaningful engagement is a very important role of the court, but it isn't enough, right? Because social rights are not just rights to a fair process or to a right to some kind of right to participate in decision making. Social rights are rights to certain concrete goods and resources, which people are entitled to by virtue of being human and having a certain dignity. And this leads to problems. So in a case in South Africa, for example, where people came and said, we do not have sufficient water, right? And the government had defined sufficient water as 25 liters. The Constitutional Court said, we're not prepared to define what sufficient water is. This is for the government to do and define what sufficient water is. They said, all we must determine is whether the government is being reasonable or not. The problem is you can't determine reasonableness without determining what is sufficient water, right? So you have to actually have some kind of standard in some sense of what is sufficient water. And then because the government was a bit responsive to the people, the court said, we're not going to do anything to determine the standard or rule what you are entitled to. And this was a community which was suffering terribly from people with HIV. They were a community that was many people were sick, and it was not possible to respond because there was no content to the right in detail. It was simply a procedural notion.
David, I'm sorry.
Okay, so I need to finish.
Yeah,
okay, good. Two last points in response, and then they'll be short. The first is context. Of course, one needs to take human rights. When you have a general standard, that general standard will have some relationship to context. So you can have a right to necessary conditions for survival. In India, that may mean being protected from the heat. In a northern European country, it's going to be related to the cold. There are going to be differences of context that come into the very definition of rights, and the general standards mediate the relationship between context and generality. The point is, context can't determine things alone. You need standards to apply to context. Okay? So you need standards in relation to context. And I think the last point was your question about deficiencies in institutional arrangements and the courts and their roles in this area. In my view, what we need to see, and one of the things we're starting to grapple with, is when courts start taking a more strong role, this places a huge burden on them, such as the Constitutional Court has in Colombia. It's actually making accessible social rights. And the question is, and that's something constitutional theorists need to deal with and institutional builders, what institutions do we need to give meaningful content to these social rights where courts assume those roles? And that can be special institutions which are structured to monitor what other branches of government are doing and report to the courts in some ways. But we need to think creatively about how practically, effectively to give effect to these rights. Thank you.
Me acaban de pedir que haga una cosa terrible, pero como Octavio y David son como colombianos por adopción, la voy a hacer, y es que tenemos que parar porque llevamos 10 minutos de atraso.
We're going to have to stop there because we are, in fact, 10 minutes behind.
Muchas gracias a los panelistas y a todos ustedes. Muchas gracias.
Muchas gracias.
Thank you for joining us. Before going to the last session, we will have a coffee break, and we also encourage you to visit the exhibition area where you may find many books that are interesting to all of you, and we'll be back here in 20 minutes.